Yeah, I'm really sorry for this. Okay, so Yukta, she has recently completed her master's in maritime law at Gujarat Maritime University after successfully completing her professional degree in law from Mumbai University. She was also a part of the students' exchange program organized by GMU, where she had the opportunity to visit famous Erasmus University in Netherlands during February 2023. During her externship, she gained first-hand experience of the port operation, logistics, and processes at the port of Rotterdam. She also had the opportunity to interact with professionals from various areas within the maritime industry. And Yukta has been keen interest in exploring niche areas of law and also has showcased her skills in oratory, public relations, and debating at various moot competitions. And in addition to that, she has completed certain online certification course as well as online training centers from the reputed training organizations. And in addition to all of these things, she is currently pursuing her advanced diploma in alternative dispute resolution from Nalsar, Hyderabad, along with other curricular activities. So we are all going to listen to Yukta to speak about this international commercial law and maritime law and share her expertise with her. So yeah, happy learning everyone, and it's over to you, Yukta.
Thank you so much for the introduction. I'll just share the slide. I hope you all can see the slide, the PPT.
Yes, Yukta, it is visible.
Okay. So good evening, everyone. I hope you all are doing good. This lecture is about Introduction to International Commercial and Maritime Law, and it is like a small trailer to the world of maritime law. Let me start this session by a quote by John George. A smooth sea never made a skilled sailor. It means that it is through facing and overcoming challenges that one becomes stronger and more skilled. Let me take you through the brief overview of the lecture. We will be learning about what is law, what is maritime law, the importance of shipping in world trade, a brief history and evolution of maritime law with special reference to India. Maritime law and admiralty law, are they same or different? Sources of maritime law, the main players involved in maritime activities, main components of maritime activities, that is the ports, the vessels, cargo, etc. The legal aspects involved in maritime activities, the documentation procedure, the principles, national and international policies, the four pillars of international maritime law, also the national and international agencies in the maritime industry, dispute settlement mechanisms, the scope of maritime law in India, the opportunities and challenges in the field, and how to overcome these challenges. Upon the completion of the course, the students are expected to understand the importance of maritime legislation for countries, comprehend the nature and scope of maritime law, grasp both contractual and non-contractual principles involved in maritime law, gain an understanding of the international and domestic legal frameworks that govern maritime activities, develop the skills necessary to solve problems related to maritime law. Now, let me ask you this. What do you actually understand by the term law? Let me give you a a short analogy between law and maritime law. Now, let's imagine that the world is a big playground and the different countries are like kids playing together. Just like how there are rules in the playground to make sure everyone plays nicely, there are also rules in the world to make sure countries interact with each other in a fair and peaceful way. These rules are called laws. Now let's say that some of the kids in the playground have toy boats that they like to sail in the little pond. To make sure that everyone can enjoy playing with their boats without any problems, the kids come up with some rules just for the pond. These rules are like maritime law, which is a special set of laws just for the ships and the shipping industry. In this lecture, we will be exploring the fascinating world of maritime law. So now that we know what maritime law is, it can be called admiralty law and is a specialized branch of law that governs ship and shipping. It is a body of laws, conventions, and treaties that govern private maritime businesses and other nautical matters, as well as uh, public matters of law of the sea. Let us look at the importance of shipping in world trade. To actually know the importance of studying maritime law, shipping industry contributes to 90% of the global trade. 60% of merchant ships trade internationally, and the fleet is represented by 1.5 million seafarers from 150 different countries. About 20 million containers are traveling across the oceans every day, which generates around half a trillion of US dollars in freight rates annually. Let us look at the history and evolution of maritime law. The seaborne transport was one of the earliest channels of commerce, and rules for, for resolving disputes involving maritime trade were developed early in recorded history. Early historical records of these laws include the Rhodian law, actually of which no primary written specimen has survived, but which is alluded to other legal texts like Roman legal codes, and later the customs of the Consulate of the Sea or the Hanseatic League. In southern Italy, the Ordamenta et Consuetuo Maris at the Trani and the Amalfini laws were in effect from an early date. Admiralty law gradually became part of United States law through admiralty cases arising from the adoption of the US Constitution in the 1789. Let us look with the special reference to Indian history. The maritime trade, actually, the Indian Ocean touches the coastlines of 37 nations spanning three continents and more than half of international traffic. Indian maritime history is older than 5,000 years, going back to Mesopotamia and Indus Valley, Harappa, Mohenjo-daro, Dholavia in Gujarat, and Lothal civilizations. The world's first tidal dock at Lothal was built around 2500 BC. Its anchorage was located away from the main current to avoid silt deposition near the ports. Archaeologists in Mesopotamia and Samaria have unearthed 30 Indus seals used as stamps to mark trading merchandise and point to sign of postal sea trade between the city of Ur of Chaldees and the Gulf of Khambat in Surat in Gujarat. The trade mostly involved carnelian beads, out of which rings and bangles were made. Obviously, later semi-precious stones were also traded in the 1500 BCs. Clear indication to trade in Mauryan period is indicated in the Arthashastra. Chanakya elucidates the responsibilities of a Navadesha or superintendent of shipping. Let us look at the history of the merchant shipping in colonial India. This is the maritime law history. So, the maritime law in India has a long history and has evolved over time. The first ever act on the subject passed by the British Parliament was the Lascars Act in 1823. This act enabled rules to be made by the Indian legislature to be observed by masters and officers, owners of ships and vessels trading under the authority of the Act. In 1838, the British government passed the Bombay Coasting Vessels Act 1838. Bombay was the hub of shipping activities as it was the prime spot of the British mercantile activities. Their aim was to introduce a system to ensure the safety and survey of vessels at sea to enhance the trade. The Indian Registration of Ships Act 1841 embodied in it provisions relating to registration of sailing vessels and merchant vessels. The Indian merchant shipping law, as it existed in 19th century, has never been on sound footing. The British law was applicable to Indian ships trading in international sea voyages, as these ships were required to be registered under UK Merchant Shipping Act, and therefore technically they were British ships, although registered in India. The Indian merchant shipping law was very nebulous and sketchy. The Native Passenger Ships Act 1887 consolidated and amended the law relating to native passenger ships. The Pilgrim Ships Act of 1895 was also enacted to regulate the pilgrim ships carrying pilgrims from India to Jeddah. A new bill for an Admiralty Act in 2005 was circulated by the Government of India, which was enacted to repeal the outdated British laws and bring in an exhaustive Indian law governing claims, jurisdiction, procedure, and conflicts arising from maritime activities. The Indian Merchant Shipping Act of 1958 had two major sources: the international conventions, that is the oil pool, which is now Marpol, the Limitation of Liability Convention, Prevention of Collisions and Load Line Convention, and the UK Merchant Shipping Act. There have been two amendments in this act since then: the Merchant Shipping Bill 2013, which was done for the control of harmful anti-fouling system on ships, 2001 Merchant Shipping Bill, and the second amendment in 2013, and there is also a pending application for a Merchant Shipping Bill in 2020 amendment bill. uh, Now, what do you think? Is there a difference between Admiralty law and maritime law? I'll take you through a little history. Historically, there was a difference between Admiralty law and maritime law. Admiralty law or Admiralty codes actually originated in England and was limited to specific disputes and claims arising from contracts and torts of high seas. These claims usually involved subjects like lost or spoiled cargo, usually between a business owner who contracted for a shipment and a ship owner who failed to deliver those goods. Maritime law, on the other hand, referred to the expansion of legal protections to deal with claims relating to hazards of ocean travel or personal injuries sustained while working on a vessel. But as Admiralty law expanded to include cases involving maritime injuries and workers' rights, the distinction line between maritime and Admiralty law became blurred. Hence, while there was once a difference between the two, today these terms can be used interchangeably. Now, the different sources of international maritime law. There are national laws, the national domestic laws of each state. There are judicial precedents, which is a major source in common law countries. There are customs and international organizations. International organizations can be intergovernmental organizations like the IMO, International Maritime Organization, International Labor Organization, UNCTAD, UNCITRAL, etc. And there can be non-governmental organizations like BIMCO, CMI, which I will be taking you through in further in the lecture. There are international conventions, that is Hague Visby rules, Hamburg rules, Rotterdam rules, Marpol, Oilpol. Then there are international shipping documents, York Antwerp rules, the INCO terms, uniform rules on electronic bill of lading just on top. Now let us see who are the main players in the maritime industry. uh, Maritime trade involves the transportation of goods and commodities by sea. Okay, there are several parties involved in this process, each with their own roles and responsibilities. Here, I will give you a brief overview of the main players. The exporter, who is also called the seller or the shipper, is an individual that makes sale to a foreign country. The importer, who is also known as the buyer, is the legal individual who purchases goods from a foreign country. The carrier is responsible for transporting the container from a specified location to the destination port. There is also a freight forwarder who plans, coordinates, and monitors all necessary operations for the transport and international freight logistics, including auxiliary services and any kind of communication. There are other players involved, such as customs agent. Uh, there is shipping company who is the owner, who might be a owner of the vessel transporting goods to different countries. There are shipping agents or ship brokers. There are consolidators, insurance companies, and bankers. Uh, Now, there are different jurisdictions a vessel may be subject to when it maneuvers through the sea. The terms flag state, port state, and coastal state refer to the different jurisdiction that a ship may be subject to while at sea, while maneuvering at sea, or in the port. What is a flag state? The flag state refers to the country where a vessel is registered. This country has extraterritorial jurisdiction over its vessels sailing anywhere in the world by virtue of the nationality principle. The flag state is responsible for ensuring that its vessel comply with international regulations and standards, such as those set by the International Maritime Organization IMO. Next, the port state. The port state refers to any state with an international port. Port states have jurisdiction over foreign vessels that enter ports, and they can inspect these vessels to ensure that they comply with international regulations and standards. The coastal state, which refers to the country that has sovereignty over the territorial sea, which extends up to 12 nautical miles from the coast. I will explain it further in the lecture. What is maritime delimitation or maritime zones? Coastal states have jurisdiction over foreign vessels that enter their territorial sea, and they can enforce their laws and regulations within this zone. In order for a coastal state to exercise control beyond territorial sea and into the exclusive economic zone, it must contact the subject's vessel flag state to fulfill flag state responsibilities or develop and exercise port state jurisdiction. These three types of states play very important roles in ensuring the safety and security and environmental protection of maritime activities. I'll give you an example. If say a vessel A is a Russian vessel and it is going from Indian port to a port in say Dubai, then the flag state would be Russia. The port state, say it is maneuvering through the territorial waters of India. Then the port state, uh, then the coastal state would be India. I'm sorry, and the port state would be the destination that it is going to. That is the port of Dubai. I hope this clears any doubts regarding the state jurisdictions. Next. Uh, Actually, maritime law governs private maritime questions, disputes, or offenses and other nautical matters. In most developed countries, maritime law follows a separate code and it is an independent jurisdiction from national laws. In the maritime field, we have to generally deal with the ports, ships or vessels, cargo, the documentation procedure, international policies, government policies, human rights of seafarers, and maritime piracy, maritime environment, maritime insurance, dispute settlement, national and international agencies. Let's look into everything in brief. Port. Now, there are different types of ports in the shipping industry and marine transportation depending on their location, purpose, and function. Each type of port has its own characteristics, facilities, and services that suit its purpose and function. The main types can be said to be seaports. These are ports that are located on the coast or shore of an ocean, sea, or gulf. They can handle large seagoing ships and cargo. They can also be used for passenger travel, fishing, naval operations, etc. Now, what you see here are the pictures of Port of Rotterdam and the Adani Hazira Port at Surat, both of which I had the privilege of, experiencing or visiting firsthand through Gujarat Maritime University. The port of Rotterdam, what you see on your left, is the biggest seaport actually in Europe. The port of Rotterdam is the largest and it is the busiest ports in term of annual tonnage. It is one of the most automated and unmanned ports in the world. It has been investing in automation technologies for many years with the goal of increasing efficiency and improving trade. And the Adani Hazira port, what you see here, is a deep water port located in the Gulf of Khambat in Surat, Gujarat. It has multi-purpose jetties and has been operational since 2005. There are other ports like naval ports. These are ports that are used by the navy or other military forces for their operations and activities. Then there are fishing ports. These are ports that are dedicated to the fishing industry. They can provide facilities and services for fishing vessels and fisheries, which can be found at large throughout the Indian coast. Next, these are the types of cargo. There is bulk cargo. What you see here is bulk cargo being the sand as bulk dry cargo being transported. There is a bulk liquid cargo. You can see here. Then there is breakable cargo. These are the general cargo in the form of bags, boxes, crates, drums, or barrels. Then there is neo bulk cargo. It comprises of goods that are pre-packed, heavy machinery, lumber, bundled steel, scrap iron, waste paper, and cars. Then there is refrigerated cargo. It is, I think, self-explanatory. There is this is not like a exhaustive list. Then there are passenger as cargo, which can be attributed to cruise ships. There is roll on and roll off cargo, and so on. Categories of vessels. There are 5 categories of vessels. Again, the names are very self-explanatory about their uses. There are naval vessels, then fishing vessels, cargo vessels. There are service vessels and specialty vessels are designed for specific tasks such as research base or ice breaking or cable laying, firefighting, etc. Then there are different types of ships or vessels. Those were the categories of vessels. Now the individual vessels. Again, this is not an exhaustive list. Now cargo ships can be classified into various types based on their purposes, size, type of cargo, etc. Some examples of cargo ships include container ships, bulk carriers, and tanker ships. Tanker ships are, you can see this on the right side. There are container ships which are designed to carry large quantities of cargo compacted in containers. There is barge. Yeah, see that this is the barge which is carrying coal in it. The barge is actually a type of vessel primarily used for transporting cargo. Barges are actually not independent vessels or boats, but are floating vessels generally towed or tugged along with other vessels. It is a flat shaped in the bottom, just like a raft, to ensure enhanced capacity. More of the cargo can be hauled and transferred. Barges are mostly used in smaller water parts like rivers, lakes, and canals. Uh, but now I think they are being used more often in the seaports as well. There are bulk carrier ships. They transfer bulk quantities of cargo. Generally, it is loose cargo without specific packing, and contains like items like food, grains, ores, coals, and even cement. See this barge that is carrying loose cargo of coal like this. Then there are tanker ships, which are specialized vessels for carrying a large amount of liquid cargo. They can be further divided based on the cargo they carry, such as oil tanker, liquefied gas carriers, and chemical and product carriers. See that this is a gas carrier here, right here. Then there are dredges. These are the dredges. They are specialized ships used for excavating and removing material from the bottom of the water to maintain a deepened water ways. So sometimes what happens is there is silt deposition near the ports, and what you see this ship, this is actually just the one third of what the whole ship actually is. So you can only imagine how much space it needs in the on the bottom of the ocean. So if the port is having a lot of silt, then there can be grounding of the vessel. The vessel can get stuck in there, so that these dredges, they actually, excavate and remove the silt near the port. There are offshore ships which are used for oil and gas exploration and production. Then there are tugboats, pilot boats, etc. See, this is a tugboat. It is actually a very small but a powerful boat designed to push or tow larger vessels, such as the barges or ships, in and out of ports through narrow waterways. They are very essential in maneuvering large vessels that cannot move on their own, and they need assistance navigating through tight spaces. Now, let us focus on maritime law related aspects in brief. Charter party. Very important concept. Charter parties are written contracts between the owner of a vessel, a ship owner, and the charterer for the use or hire of a vessel. Let us look at the origin of the word charter party. So, in olden days, what they used to do, the shipmaster generally owned the vessel. However, the shipmaster would conduct his negotiations in person in whatever port the ship was maneuvered, draw up a contract with the trader, and actually tore the contract in halves. One half was kept with the trader, and the one half was kept with the shipmaster. This is the origin of the term charter party, which actually means charter meaning a document, and partita meaning being divided or split. So, so this is the origin of the term. And now it is used as charter party, which is an agreement between a ship owner and a cargo owner. It has to be in a written format, and it is for the carriage of goods from one port to another. Moving forward, the main players in the charter party are charterer, the ship owner, and the ship broker. I think now we all know what the three players mean. Moving towards the types of shipping operations, there are two types of shipping operations taking place: a liner trade and a tram trade. Liner trade refers to scheduled shipping services like that adhere to predetermined routes and fixed timetables. On the other hand, tram trade offers flexible shipping services on an ad hoc basis without adhering to strict schedules or routes, and offers more flexibility in terms of routes and schedules. Now, another way to think about the difference between them uh, is that to think a liner trade as a courier service that follows a fixed route and schedule, while a tram trade is like a taxi service that can be hired and on demand and go anywhere the customer wants. Then the tram trade or charter party is further divided into voyage charter and time charter. Yeah, types of tram trade or charter party: voyage charter and time charter. I will give you again a very quick analogy. Let's imagine that the ships are cars, okay, and the charter parties are car rental agreements. To make it easier to understand, in under voyage charter, this is like booking an Ola or a Uber ride. The ship owner, that is the Ola or Uber driver, agrees to transport a specific cargo, in this case you, from one port, that is your pickup location, to another, that is your destination, for an agreed price, that is the fare or freight. The ship owner is responsible for all expenses related to voyage, such as fuel, port charges, etc. In time charter, this is like renting a car for a specific period of time. The ship owner, that is the car rental company, that is say Zoom Car, agrees to let the charterer, that is you, hire the vessel, that is the car, with or without the driver for a predefined period at an agreed amount payable by the charterer. The charterer is responsible for the operating expenses, in this case, that is the fuel, the port charges, etc., while the ship owner remains responsible for the crew if it provides, and maintenance of the vessel. And you can see the differentiation given here. The different standard forms of contract in voyage charter are mostly GenCon is used, then Asbentakov, then Synocoms. Then in time charter there is NYPE, Baltime, Shelltime, Bearcon. These are the main standard form charters. Then time charter. This the time charter can again is further divided into two. That is a demise charter or a bareboat charter. Um, Now, in this case, if the in demise charter, if the ship owner leases the ship with the ship owner's crew members, that is called demise charter. And if he gives the ship leases the ship without the crew members, it is bareboat charter. As simple as that. Next, moving on to a bill of lading. A bill of lading is generally issued by the master or captain of the ship on behalf of the ship owner to the shipper. Uh, Let us say a bill of lading is like a ticket you get when you check your coat at a fancy restaurant. Just like how the ticket proves that you own the coat and you can pick it up when you are leaving, a bill of lading proves that someone owns the goods that are being shipped and can pick them up when they arrive at their destination port. It is a legal document issued by a carrier, like a shipping company, to the shipper, the person who is actually sending the goods, that details what's being shipped, how much there is, and where it's going. It also serves as a receipt when the carrier delivers the goods. It is a form of liner trade and considered more than a contractual document. There are three major functions of a bill of lading. It is called as a receipt of goods shipped, an evidence of contract, and a document of title. Some of the main cases are highlighted here. The David Egmashali case, where it is said that a master's duty is there in closing bill of lading. I'll tell you in brief what happened. So there was some 35 tons of prilled urea was carried. The master of the vessel issued a closed bill of lading as certain part of the cargo was discolored. Like there are various kinds of bill of lading, and closed bill of lading is if there is something that the extra that the master has to write on the bill of lading, that is called a closed bill of lading. But this bill of lading was issued on behalf of the master, which was based on the mate received. That is someone else, the mate had actually surveyed the ship and he had made the comment, and it mentioned that the cargo was discolored and plastic rust, rubber, stone particles were found in the cargo. Justice Coleman in this case said that the captain or master must be observant and should himself check whether the cargo is in good condition or not, and not depend on the mate receipt. So the liability or the responsibility lies with the master of the vessel. There is again a case of Grant versus Norway. Uh, you can Google it later. Then again there is then on the evidence, like bill of lading as a evidence of contract. There is a case called SS Deans, who is a cargo owner, versus SS Deans, who is a ship owner, in 1951. There was a oral contract. The plaintiffs actually shipped 3,000 cartons of mandarin oranges from Colombia to London. They received an oral undertaking from the ship owner's agent that the vessel would proceed directly to London. The bill of lading contained provision to call at other ports, and the ship sailed to Antwerp firstly. This caused the plaintiffs to pay a higher rate of import duty, and the market price for the oranges fell. The court held that bill of lading is not in itself a contract between the ship owner and the shipper. It, at only best, is an evidence of a contract. Shippers are entitled to pay damages for the extra duty paid and the fall in the market price. Uh, the third, that is bill of lading as a document of title. It was held in Sander Brothers versus McKellen and Co. That the receivers have the right to receive all the number of bill of lading copies issued with without which he can actually refuse to take the cargo at the port of destination. That is, if 10 original bill of ladings were issued, he should get them all. Moving on to another other two very important concepts called salvage and towage. Um, okay, now let's imagine that the ocean is like a big highway and the ships are like cars driving on it. Sometimes a car may break down, or get into an accident, and it needs to be towed to a repair shop. This is like salvage operations, where a ship that is in distress is rescued by another ship. Now let us say that there's a car that's really sorry. Okay. Now let's say that there's a car that's really slow and can't keep up with the other cars on the highway. To help it move faster, another car might attach a tow rope to it and pull it along. This is like towage, where one ship tows another ship to help it move more efficiently. I hope these concepts are clear to you. I've also written that salvage refers to an act of saving vessels that are in danger. This can include rescuing a ship that is sinking, on fire, or in danger of breaking apart. Salvage operations are often complex and can involve multiple ships and specialized equipment. You can see here like a ship is being drowned, then the salvage operation starts. You can see here a tugboat that you can see a rope that it is pulling a huge vessel. So this is towage and this is salvage. Moving forward, yes, there is this very famous case in 2021, the grounding of the vessel Ever Given in the Suez Canal. So what happened was in March 2021, the Suez Canal was blocked for 6 days by this ship called the Ever Given, which was a container ship, and it had ran aground. Uh, so basically, the 400-meter long ship was hit by strong winds on the morning of 23rd March, and it ended up being jammed across the waterway with its bow, that is the front part that you can see here, the bow and the stern, that is the rear end or the back, stuck between the canal and blocking all the traffic until it could be freed. Now, why is Suez Canal important? The Suez Canal is important because it is the shortest maritime route from Europe to Asia. I will show. Yeah, see, this is the Suez Canal route through Egypt. And earlier, when this route was not made, the ships had to go all the way through, from here, from Cape of Good Hope, tip of Africa, southern tip of Africa, to reach another side. The canal actually separates the African continent from Asia, and it provides the shortest maritime route between Europe and the lands laying around India and Western Pacific Oceans. It is one of the world's most heavily used shipping lanes. The canal extends only up to 193 kilometers, that is 120 miles, between the port in the north and Suez in the south, with approach canals. The blockage actually had a significant negative impact on trade between Europe, Asia, and the Middle East. On 28th March, at least 369 ships were quivering to pass through the canal. This jammed the whole world. The case of the Ever Given is an example. See, Ever Given is, yeah. So the case of the Ever Given is actually an example of both salvage and towage operations, because after the ship was stuck like this in the Suez Canal, uh, a team of salvors worked to free it. This involved dredging of sand from around the ship. You can see your tugboats and salvage boats. This who actually helped the boat, free its way. Once the ship was freed, it was towed to the Great Bitter Lake for further inspection. In this case, the salvage operation involved rescuing the Ever Given from its grounded position in the canal. The towage operation involved moving of the ship to a safe location where it could be inspected. Both operations were critical in resolving the situation and restoring a normal traffic flow through the canal. Now moving onwards to maritime insurance and protection and P&I clubs, protection and indemnity clubs. The maritime insurance is a type of insurance that covers the risks and losses related to ships, cargo, terminals, and any transport or property by which cargo is transferred, acquired, or held between the points of origin and final destination. And P&I clubs are special type of marine insurance providers that covers third party liability. They are non-governmental, non-profitable, mutual or cooperative association of ship owners, operators, charterers, and seafarers who pool their resources to cover their own civil liabilities and risks. Let me give you an example. If say a ship collides with another ship, then the marine insurance will cover my expenses, that is the cargo or anything that has happened to the hull and machinery, depending on what kind of insurance I have. And the P&I clubs will cover the third party liability, that is the other ship's liability, the damage happening to the cargo or loss or shortage, or anything happening to the other ship, basically. Now, let us see the role of international conventions and treaties. They play a crucial role in harmonizing maritime law. International instruments are developed, adopted, ratified, amended, and enforced by various international organizations, the primary one being the United Nations. This international maritime law can be divided into private international maritime law and public international maritime law. Private international maritime law uh, covers Hague-Visby rules, Hamburg rules, and Rotterdam rules. So these international conventions regulate the rights and obligations of carriers and cargo owners in the international spectrum. They establish minimum obligations, minimum immunities, and the limitation of liability for the carriers. The Hague-Visby rules are a slightly updated version of the Hague rules, which were drafted in Brussels in 1924. They apply to bills of lading or other similar documents of title, but not to charter parties. The rules cover the period from the time when the goods are loaded on the loaded and to the time when they are discharged from the ship. In terms of ship owners, that is why they are called tackle to tackle. This in this case, there is least liability of the ship owner. So it means that the moment when a ship's tackle is hooked on at the loading port until the moment when the ship's tackle is unhooked at discharge. Hague-Visby were adopted by India in the way of Indian COGSA, Indian Carriage of Goods by Sea Act 1924. Moving on to Hamburg rules, these were adopted in 1978 and they govern the international shipment of goods. They apply to contracts of carriage by sea, including bill of lading and other transport documents. The carrier is responsible for the goods while they are at the port of loading, during the carriage, and at the port of discharge. That is why they are called port to port, and the ship owner has moderate liability. The Rotterdam rules were adopted in 2008 and provide mandatory standards of liability for loss or damage arising from the international carriage of goods by sea. They apply to contracts for the international carriage of goods wholly or partly by sea, including electronic transport records, and charter parties are excluded. Rotterdam and Hamburg actually increased the ship owner's liability. The old conventions were never repealed. That is the Hague-Visby rules. So ship owners, even today in the international commercial maritime trade market, go with the Hague-Visby because it mostly favors the ship owners and because it is widely accepted and ratified by many countries. Another reason that ship owners favor Hague is because the conditions under it are more beneficial to them. As you can see, the liability keeps on increasing with the Hamburg and Rotterdam rules. The Rotterdam rules are mostly multimodal, used for multimodal transport. That is why it is called door to door. So the liability, again, you can see how the liability increases for the ship owner. So the most favorable rules are the Hague-Higgsby rules for the ship owners. Coming towards public international maritime law, the which is mostly governed by the United Nations, which is an intergovernmental organization whose stated purpose is to maintain international peace and security, develop friendly relations among nations, achieve international cooperation, and serve as a center for harmonizing the actions of nations. It is the world's largest international organization. Now, UNCLOS, in a way, the UN has adopted several conventions on general aspects of maritime law, one of which being the United Nations Convention on the Law of the Sea, or the UNCLOS, 1982, which defines the rights and duties of states in different maritime zones, such as territorial sea, exclusive economic zone, continental shelf, high seas, and international seabed area. The UNCLOS also establishes mechanisms for dispute settlement and cooperation among states on various issues such as maritime scientific research, conservation of living resources, protection of the marine environment, and exploration and exploitation of mineral resources in the seabed. This is the maritime zones that is provided under the UNCLOS. Okay, UNCLOS permits coastal states to establish several different maritime zones, each of it with its own set of rights and duties for the coastal state. In general, a state has more rights in zones nearer to the coast, that is the territorial sea, exclusive economic zone, than it has further to the ocean, that is in the high seas. Some of the main maritime zones established by the UNCLOS are the internal waters, the territorial sea, contiguous zone, exclusive economic zone, the EEZ, and the continental shelf. The internal waters are all the waters that fall inland, the landwards of the baseline, such as lakes, rivers, and tide waters. States have the same sovereign jurisdiction over internal waters as they have over any of its territory. There is no right of innocent passage through the internal waters. Coming to the territorial sea. Now, if you say this is the baseline of the coastal state, then the territorial sea extends up to 12 nautical miles from the baseline of the coastal state. Uh, the coastal states have sovereignty and jurisdiction over the territorial sea, including it all includes the seabed, the subsoil, and the airspace. However, this sovereignty is limited by the right of innocent passage of other states, that is ships of other countries, the flags other flag states can maneuver in the territorial sea. They have the right of innocent passage. Coming towards the contiguous zone, which extends up to outer limit of the territorial sea to a distance of 24 nautical miles from the baseline. So this total is 24 nautical miles, and to a further 12 nautical miles from the territorial sea. So, in this zone, a coastal state may exercise control necessary to prevent or punish infringement of its customs, fiscal, immigration, or sanitary laws and regulations within the territory or territorial sea. Coming towards the exclusive economic zone, which extends to a distance of 200 nautical miles from the baseline. So, from the baseline that is here, it extends up to 200 nautical miles somewhere here. In this zone, a coastal state has sovereign rights for the purposes of exploring, exploiting, conserving, and managing the natural resources, whether they are living or non-living, and the water superjacent to the seabed, and the seabed as well as the subsoil. So this part is the subsoil. Then there is a continental shelf, which comprises of the seabed, the subsoil, the submarine areas, and extend beyond the coastal states' territorial sea throughout the natural proclination of its land territory to the outer edge of the continental margin to a distance of 200 nautical miles. And then after 200 nautical miles from the baseline, there is the high seas, which extends further. And this deep sea bed, all the deep sea bed in the high seas, is called the area. So this is the whole maritime zones and maritime delimitation of water for provided in the UNCLOS for every coastal state. Coming towards the international organizations, the major one being International Maritime Organization. So it is a United Nations specialized agency that deals with technical safety, environmental, legal, and security matters related to shipping. The IMO has adopted more than 50 conventions and protocols on various topics. Sorry, such as safety of life at sea, the SOLAS, the prevention of pollution from ships, MARPOL liability compensation regime, the STCW, that is training and certification of seafarers, then SUA convention, suppression of lawful activities, just to name a few. It was established in the 1948 following an agreement at a UN conference in Geneva, and the original name of the organization was IMCO, that is Intergovernmental Maritime Consultative Organization. But the name was later changed to IMO in around 1982. Moving towards the International Labour Organization. It is also a specialized United Nations agency whose mandate is to advance social and economic justice by setting international labor standards. It brings together governments, employers, and workers of 187 member states to set labor standards, develop policies, and devise programs promoting decent work for all women and men. The ILO has adopted several conventions on the working conditions and rights of seafarers. The major one being the Maritime Labour Convention of 2006, that is MLC, which sets minimum standards for employment, hours of work, rest, healthcare protection, welfare, social security, and complaint mechanisms for the seafarers under its provisions. The MLC also provides for inspection and certification of ships to ensure compliance with its provisions. Now, what we have learned are these are the four pillars of international maritime law. The International Convention for the Safety of Life at Sea, 1977, which is also called SOLAS, being the first, is an international treaty that sets minimum safety standards for the construction, equipment, and operation of merchant ships. The International Convention on Standards of Training, Certification, and Watchkeeping for Seafarers, STCW, 1978. It sets minimum qualification standards for masters, officers, and watch personnel on seagoing merchant ships and large yachts. The third one being MARPOL, that is the International Convention for the Prevention of Pollution from Ships, 1973. It is an international treaty that aims to prevent pollution of the marine environment by ships from operational or accidental causes. And the fourth being MLC, which is the most important and the recent introduced by ILO. The convention sets out seafarers' rights to decent working conditions on board ships. These four conventions, they actually work together to ensure the safety, security, and environmental protection of international shipping, as well as to promote decent working conditions for maritime workers. They are developed, adopted, ratified, amended, and enforced by various international organizations, two of them being the IMO and the ILO. Coming towards the dispute resolution mechanisms. There are different dispute resolution mechanisms in international maritime law, which are almost similar to any of the other dispute resolution mechanisms. First one being negotiation, which is a process where the parties directly communicate with each other to reach a mutually acceptable solution. So basically, negotiation is the first step in any dispute resolution process. It is voluntary and flexible, also cost effective than litigation. But however, they might not always succeed, especially if there is a power imbalance or a lack of trust between the parties. So the next resolution mechanism that one might prefer is mediation. This is a process where a third party called a mediator generally assists the parties in finding a common ground and facilitating a settlement. Mediation is also voluntary, flexible, and cost effective, but it has the advantage of involving a neutral and impartial person who can help overcome impasse and generate options. But again, however, mediation does not guarantee a binding outcome, as the parties retain the right to accept or reject the settlement. The next process is the arbitration process, where a third party called an arbitrator or an arbitral tribunal decides the dispute based on the evidence and arguments presented by the parties. Arbitration is usually based on an agreement between the parties, which can be either before or after the dispute arises. Arbitration has the advantage of being faster, cheaper, and more confidential than litigation. It also allows the parties to choose arbitrators who are experts in the field, in this case, maritime law and practice. However, arbitration also has some disadvantages, such as limited appeal rights, lack of transparency, and potential bias or inconsistency. Litigation, the last resolution mechanism. So, this is a process where a court or a judicial tribunal decides the dispute based on applicable law and facts. Litigation is usually initiated by one party against another party without their consent. Litigation has the advantage of being authoritative, predictable, and enforceable. It also provides for judicial review and appeal rights. However, litigation, as we all know, has the disadvantages such as for being slow, expensive, and adversarial. It also may involve jurisdictional or procedural complexities, or conflict of laws in this case, because it is of international nature. These are some of the dispute resolution mechanisms under international law. Each mechanism, you have to see, has its own advantage and disadvantage. So therefore it is very pertinent for parties to carefully consider their options and choose most suitable mechanism for quick redressal of their disputes. uh, Now, there can be ad hoc or institutional dispute resolution. Ad hoc, there is International Court of Justice. It is actually a principal judicial organ of the United Nations that settles legal disputes submitted by states in accordance with the international law. The ICJ has dealt with several maritime disputes in its history. The prominent one being the North Sea Continental Shelf case in 1969, where Denmark and Netherlands brought separate cases against Germany, considering the delimitation of their continental shelf boundaries in the North Sea, the maritime boundary delimitation that we saw earlier. So there were conflict between Denmark and Netherlands on the same. Then there is another case of maritime delimitation between Greenland and Jan Mayen case, where Denmark brought a case against Norway concerning their maritime boundary in an area between Greenland and Jan Mayen Island. There is another case of maritime delimitation in the Caribbean Sea and Pacific Ocean in 2018, where Costa Rica brought a case against Nicaragua concerning their maritime boundary in both seas. There is another specialized tribunal, ITLAWS, that is the International Tribunal for the Law of the Sea, which is an independent judicial body established by the UNCLOS. It specifically deals with the dispute arising out of interpretation and application of the unclause. The it laws has dealt with several maritime dispute in its history. Uh, some of it being the MV Sega case, where St. Vincent and Grenadines brought a case against Guinea concerning an incident involving a vessel flying its flag that was arrested by Guinean authorities for alleged smuggling activities. And there are a lot of other cases that ITLAWS has dealt with because it being a special maritime tribunal. Again, there are institutional mechanisms like SIMAC, the Singapore International Maritime Arbitration Center, which is an independent institution that provides arbitration services for maritime disputes under its own rules or rules chosen by the parties. The SIMAC has dealt with several cases again, considering disputes between ship owner and charterer concerning the performance of a voyage charter party contract and payment demurrage or delivery of the vessel, and etc. Then there is LMA, the London Maritime Arbitrators Association, which also provides arbitration services for maritime disputes under its own terms or other terms chosen by parties. Then there is HKAC, the Hong Kong Arbitration Center. It is not a specialized arbitration center for maritime activities, but in general, arbitration center which also takes up maritime arbitration cases. Then you can see for the regional ones there is a recently established one, that is this is the first in India for maritime arbitration. There is the Gujarat International Maritime Arbitration Center in Gift City in Gandhinagar, Gujarat. Then there is a already established Mumbai Center for International Arbitration. Again, this is not a specialized arbitration for maritime. This is a general arbitration institutional, which also takes up maritime cases. GMAC being the first of India's International Maritime Arbitration Center. Then coming towards Indian legislative frameworks. So India has a lot of maritime acts. I will talk about all of them in brief. The I'll start with the Territorial Waters Continental Shelf Exclusive Economic Zone and Other Maritime Zones Act 1976. This act defines the extent and limits of the maritime zones of India, such as the territorial sea, the contiguous zone. So it actually brings into effect the maritime delimitation given under the UNCLOS. It also specifies the rights and obligations of India and other states in these zones, such as the sovereignty, jurisdiction, navigation, exploration, exploitation, conservation, and management of all the marine environment and maritime activities happening. The coming towards the Merchant Shipping Act of 1958. So this act is the major majority of the cases come under this act, because it regulates the registration, construction, equipment, operation, safety, security of Indian ships as well as their crew. This is for Indian merchant vessels. It also deals with matters such as liability of ship owners and operators, the carriage of goods and passengers by sea, the prevention of collisions and pollution at sea, the salvage and towage of ships, the investigation of maritime casualties and accidents, and etc. So this is basically Merchant Shipping Act is for Indian registered vessels. Then there comes the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, one of the recent acts. This actually consolidates the law relating to admiralty jurisdiction of ports, admiralty proceedings of maritime claims, arrest of vessels, and other related matters. Then there comes the Major Port Authorities Act of 2021. This act replaces the Major Port Trusts Act of 1963 and aims to provide greater autonomy and flexibility to the major ports in India. It empowers the board of each major port authority to manage its assets, resources, and infrastructure. Then there comes the Yeah, so this the Major Port Authorities Act also establishes an adjudicatory board to resolve disputes between port authorities and port service providers. The Marine Insurance Act of 1963. This act governs the contracts of marine insurance in India. It defines marine insurance as a contract whereby one party undertakes to indemnify another against maritime losses arising from perils incidental to maritime adventure only. Um, then coming towards the Indian COGSA, the Indian Carriage of Goods by Sea Act of 1924. This act brought into effect the Hague-Visby Convention in India, as I stated earlier. Then there is this latest Maritime Anti-Piracy Act of 2023. This is a proposed legislation that aims to prevent and combat piracy in Indian waters and beyond. It defends this was my dissertation topic. I reviewed the Maritime Anti-Piracy Act of 2022. So, to give you a brief glimpse about it, before this act, the all the piracy cases, maritime piracy cases in India were dealt with under the Indian Penal Code 1860. But it was not like IPC, as I've written, is not valid for foreigners and in international waters that is beyond 12 nautical miles from the coast. So there was a lack of jurisdiction to uh, with the piracy cases in India. So this Maritime Anti-Piracy Act of 2022 was brought in, and this has been actually enacted to give effect to UNCLOS Article 100, that is, all states are to help in the suppression of piracy, cooperate in the suppression of piracy by bringing towards some acts, and this applies to the high. This has extended our jurisdiction not only to the territorial sea but to the high seas, and now the cases of piracy happening in the high seas are under the jurisdiction of the co- of India, if it is happening near the coast of India. Now, the role of various agencies in enforcing and administering maritime law in India. There is DG Shipping, the Directorate General of Shipping, which is a regulatory authority for shipping in India under the Ministry of Ports, Shipping and Waterways. It deals with implementation of shipping policies and legislation so as to ensure the safety of life and ships at sea, prevention of marine pollution, uh, promotion of maritime education and training in coordination with the IMO regulations of employment and welfare of seamen. There is Indian Coast Guard, the ICG, is a maritime law. It is actually a maritime law enforcement and search and rescue agency with jurisdiction over India's territorial waters, including the contiguous zone and exclusive economic zone. It is responsible for protecting India's maritime interest and enforcing its maritime laws in these zones. It also provides assistance to other agencies such as the Indian Navy, the Department of Fishing, the Customs Department, the Central Armed Police Forces, the State Police, pollution prevention, fisheries protection, etc. So after the Kasab incident, actually the Indian Coast Guard has regulated more laws and security regimes throughout the coast. Then there comes the Maritime Board. There are different maritime boards in India: the Maharashtra Maritime Board, Gujarat Maritime Board, Kerala Maritime Board. The boards are statutory bodies which are actually established by the respective state governments under the Indian Ports Act 1908 and the Maritime Board Act 1996. They are responsible for the administration, control, and management of the minor ports and inland waterways within their respective states. They also facilitate the development of port infrastructure, trade and commerce, coastal shipping, inland water transport, fisheries, tourism, education in their respective regions. Now coming towards the scope of maritime law in India. It is quite broad and promising. Maritime law is a branch of law that regulates the activities and disputes that occur in the seas and other navigable waters. Maritime law covers a wide range of issues such as the rights and obligations of states, the ownership of use of vessel, protection of the marine environment, the safety and security of navigation, the prevention and settlement of disputes, and the compensation for damages. India is a country with a long coastline and a rich maritime heritage. India has also been involved in maritime trade and commerce since ancient time. India has also been a party to various international conventions and treaties, be it UNCLOS or conventions related to IMO or ILO. India has also enacted several domestic laws and regulations to govern maritime matters that we saw earlier. The scope of maritime law in India is really not limited to legal issues only. It also encompasses various prospects of maritime economics, management, policies, security, technology, education, research, and much more. There are many opportunities for maritime lawyers in India as well to work in different sectors and fields related to maritime affairs, such as shipping companies, insurance companies, government agencies, law firms, arbitration tribunals, academic institutions, and research organizations. Now, what are some of the benefits of pursuing a career in maritime law in India? This is the law aspect. Actually, it is very, or it can be broadened to just the maritime career in India. It is actually a very dynamic and changing field that requires constant learning and updating of knowledge and skills. It is a global and interdisciplinary field that involves interaction and collaboration with professionals from different countries and backgrounds, thus making it an international study. Sorry. It is also a rewarding and lucrative field that offers attractive remuneration and growth prospects. It is a socially relevant and responsible field that contributes to the development and welfare of the nation and the world in large. You one may also face some challenges or pitfalls in the career in maritime law in India, as it is a complex and competitive field that requires high level of expertise and experience. It is also demanding and stressful because it requires long working hours and frequent travel. It is a regulated and restricted field that requires the laws to be complied with. It is a very risky and uncertain field, obviously, that involves exposure to various hazards and liabilities. But what can you do to overcome these challenges? One needs to have certain skills and qualities, like having a strong academic background and qualification in maritime law or related fields, having a good command over English language and communication skills, a keen interest and passion for maritime affairs and issues, sound analytical and logical reasoning ability, creative and innovative problem solving approach, flexible and adaptable attitude towards changing situations, and also, very important of all, a professional and ethical conduct towards clients and colleagues. So there are many institutions and organizations that offer courses, training, internship, or employment opportunities in maritime law in India. Some of them I have mentioned here, like the Gujarat Maritime University, which I just completed my LLM in maritime law from. It is actually formed under the Gujarat Maritime Board that we saw earlier. It offers various courses in maritime law at certificate level, diploma, postgraduate, diploma, master's, doctrinal, and executive educational levels as well. It also conducts research projects, seminars, workshop, conferences on maritime law related topics. There is again Nalsar University, which offers LLM program in maritime law with specialization in international trade or maritime or marine environment law. It is also a center for air and space law, which is a nice field that conducts research activities and maritime law related issues. It also has, like, I am pursuing an advanced diploma from Nalsar currently. So it also has an advanced diploma in maritime law, air and space law, and other fields. There is also NLU Odisha offering LLM in maritime law. And it also has a center for maritime law that conducts research and activities on maritime related issues. There is also MNLU, Mumbai National Law University in Powai, which offers a LLM in maritime law and is also a center for maritime uh, law. There is Indian Maritime University. It offers various courses in maritime studies at undergraduate, postgraduate, and doctrinal levels. It also provides training programs for several seafarers. There is IIT Madras that offers courses in ocean engineering at undergraduate, postgraduate, doctrinal levels. It also has a Center for Ocean Engineering that conducts research activities on ocean technology related issues, very technical. Then there is IIM Ahmedabad. It offers various courses in management postgraduate diploma level. It has a center for transportation and logistics that conducts research activities on transportation of maritime management related issues. For training or internship opportunities, you can see there is Indian Coast Guard, which we talked about earlier, that it is a law enforcement agency that protects India's maritime interests and enforces maritime laws. It also provides assistance to other agencies in matters related to maritime security, safety, pollution prevention, etc. Then again, there is DG shipping that we talked about. Then there are maritime boards. Um, yeah, I think these are like some of the areas you may explore. Yeah, I think that is the end of the lecture. And if you have any questions or feedback that you would like to give,
Uh, yes, you can unmute yourself and ask the question, or you can even drop messages in the chat box. If you have any questions related to career in maritime law, even then you can ask.
or you can contact me later if you get any doubts. I hope this lecture was good and it solved any doubts or
Yeah, it did not feel like you are doing it for the first time, very honestly. It was
thank
not at all like that you are doing it for the first time in front of these mixed audience. I never felt it throughout this session. This is a very honest feedback from my end.
thank you so much. It means a lot.
Yeah, you are like confident and you carried things uh, throughout the session very well. Either it may be your soft skill or the depth of knowledge that you have in the subject, you carried it really well.
Thank you so much.
Okay, so I hope we do not have any questions. I think we are good to wind up. Thank you, Yukta. Thank you so much for sparing your time. I know by the quality of the PPT, I can make out that you have spent a good amount of time in searching for the content, preparing the slides, aligning it. That was really very nice. And also, in the slides, I can understand that I felt that you already knew the pulse of audience, like what they are looking for and what would make them attractive. For example, the kinds of ships that you showed, there were images. So without images, if you would have told that this is like Ola, Uber, this is that, this is for carrying oil, I think it would not have been in our minds. Now I think that is in my subconscious mind. I know it
Yes.
is.
Yes,
And
that is how I actually taught myself and I
yes,
myself learned. So I presented it in that format.
yeah, that was really good, and that was like something that would stay in my mind for forever. That Yes, I can. If somebody is speaking of types of ships, I think that picture would come into my mind.
Yeah, exactly.
Yeah, so that was like really very nice, and I understood that. I realized that yes, you know the pulse of the audience, and you know what would make them interesting, and what would stay in their minds and hearts forever. That was really very nice, and it was really very good. Apart from the academic subject, even you stepped out of the zone and you spoke about the career opportunities and other things, which I think is in need of the hour, because
Yes,
all
definitely.
of us, yeah, because all of us like would like to fit in in our comfort zone, like LLM in constitution, LLM in criminal. I'm not telling that they are bad, even I have specialization in that, but I think it's a high time we move out of that conventional subjects or traditional subjects and explore something new, so that we are ahead of the competition.
Yes, yes. Very truly said.
Yeah. So that was really very nice and very much impressive, and then we are really happy and privileged to have you here today. And also for all the people who have attended here, thank you so much for sparing your weekend with us. And we'll be meeting you in the next session of navigating the legal landscape. Thank you so much.
Thank you.